Good morning, everyone. It is 10 o'clock and it is time for our next Brexit Endgame webinar. So this morning's session is about competition law and what will happen to competition law post-Brexit. This is one of a series of webinars that we're running at Field Fisher. And we've already had UK legislation navigating retained EU law, which was on the 17th of September. And here we are on the 24th of December doing competition law. So you have, and hopefully you can see myself, John Castles. I'm a partner here at Field Fisher. And on the other screen, you have my co-partner, Nick Pimlott. So we are partners in the competition and regulatory team here. And hopefully we can take you through some of the interesting things that might happen in the competition law sphere. Now, I am unable to move the slides forward for some reason. Oh, there we go. So as I was saying, this is one of a series. Here we are, 10 o'clock, 24th of September, doing competition law. Highlighted in red there. You will see that next week you've got the joy of myself and Nick again talking about state aid and public procurement. So same time next week. We hope to see you all then. I'm going to kick off. That's the agenda for today. So competition law landscape, what comes next? We've tried to keep it really practical. So what does this mean for me and what should I be doing? And then we'll have time for questions at the end. You do have an ability to enter questions in text via the control panel. Hopefully you can see that. And you can send them to everyone, or you can just send them to me and Nick, and we will do our best to answer them. And if we can't answer them today, we are happy to answer them afterwards. So competition law is one of those areas, I'm sure you know, where there are lots of practitioners of competition law who are able to talk about it in a theoretical sense. Actually, the magic of competition law and the magic of being, we think, good competition lawyers is really translating it into what do people do when they go back to their desk? What do they need to do differently? It's a real practical application of competition law. So we'll obviously need to talk a little bit about the legal stuff in terms of Brexit, but actually what we're going to try and focus on is, what do you need to be thinking about and what should you be doing? So the competition law landscape. So we are in September 2020. So we're about 3 months away from the end of the transitional period. So the end of the transitional period is 11 p.m. on the 31st of December 2020. And so through the transitional period, the UK has not been a member state of the European Union, but it has continued to be treated and to treat the EU as if it is still a member state. So that's what we're doing through the transition period. So what that has meant is EU law continues to apply in the UK and will continue to do so until the 31st of December 2020. So all the EU treaties, free movement rights, general principles of EU law, and indeed competition law. So primarily Article 101, Article 102, and the EU merger regulation have continued to apply throughout this period. In the background, of course, we have quite a complex legislative picture with the Withdrawal Act, and in particular in competition law, the Competition Amendment, etc., EU exit regulations, which do various things in relation to the CMA, so the UK's Competition and Markets Authority, and the specific legal provisions and specifically the transitional arrangements as we move towards the end of the transitional period, because competition investigations, both in the antitrust sphere and in the merger regulation sphere, can last for a significant period of time, and those time periods have a significant impact on businesses. So there will be investigations and merger inquiries that will span the end of the transitional period, and the amendment regulations deal with a lot of that stuff. And then it's worth saying that BEIS and indeed the CMA have published guidance on what they think will be the situation in the event of a no-deal Brexit, and it's worth just highlighting that, of course, the stated aim of the EU and the UK government is that there should be a deal. Obviously, we don't know what that deal will look like, so all we can grapple with at the moment is the existing transitional arrangements and then what we think things will look like if there's a no-deal Brexit. Nick, over to you. What comes next?
So thanks, John. Good morning, everybody. What next? Well, I mean, there's sort of a few points on this slide. I think the stated aim of the UK government, at least I guess the UK government sort of pre-election, at the moment I suppose sort of is a bit uncertain as to what direction the UK government might take. Whether or not there's a deal, but the stated aim has been to ensure, at least in the short term, kind of continuity of the law effectively as we move from sort of this transitional state into sort of true Brexit, as it were. I mean, as this first sort of fairly obvious point, I mean, EU competition law will of course continue to apply post-Brexit to agreements or conducts of UK-based businesses where it still has an effect in the EU. So if you're a UK-based business selling goods or services in the EU, trading them as between EU member states, then that will all remain subject to EU competition law. The distinction will be that, of course, insofar as trade happens only within the UK or as between the UK and the EU, then EU law will no longer apply. But of course, we have the UK competition rules in the Competition Act 1998, which drafted in essentially identical terms to the EU rules. So in terms of sort of immediate impact, I suppose the message is that sort of nothing's going to change immediately overnight in terms of the way the competition rules actually appear and in the UK legislation. I mean, there will of course be kind of practical procedural changes. Obviously, the Commission will cease to have power to investigate, to carry out dawn raids, or to essentially investigate the UK specific aspects of anti-competitive behaviour. There are some arrangements for cooperation in the withdrawal agreement, making written requests for information, and so on. But that's obviously much more limited than actually carrying out raids. So far as the sort of relationship between UK competition law and EU competition law is concerned, those of you listening who are sort of familiar with the competition rules here, Section 60 of the Competition Act is a very important provision in the Competition Act, required UK competition law to be interpreted in a manner consistent with the case law of the Court of Justice of the EU. Now, that will be revoked from the 1st of January and replaced with a new Section 60A, which is has been, I think, a sort of a section of some sort of controversy in the Brexit legislation that's gone through the UK Parliament. The question is, how much regard should the Competition Markets Authority and the courts here have to EU competition law and the kind of the decisions of the European Court and decisions of the European Commission, how much regard should be had to those when interpreting UK competition law? So Section 60A sort of has a bit of a, I suppose, a bit of a fudge in it. I mean, it says that the CMA and UK courts have to try and avoid inconsistency with EU law as it stood on exit day, so a sort of ossification of EU law on exit day. But there is quite a bit of scope in Section 60A to diverge to reflect UK specific circumstances. So what we could see over time is in CMA decisions, in court decisions involving competition law, arguments being put forward that actually, you know, this EU principle is all very interesting, but we need to, or there's a better way of doing it, and there's a sort of if you like, either a more business friendly or more consumer friendly, depending on which point of view you take, way of doing it. So there'll be quite a lot of scope for, I think, certainly for parties to have those kind of arguments with the CMA and before the courts, and also for the courts and CMA to sort of develop UK competition laws and competition law in ways which diverge from the EU rules. Sort of fairly obviously, the UK courts will no longer be able to refer cases to the Court of Justice, so that any question of interpreting, how do you interpret, competition law cases, will fall to the domestic courts to decide. And again, there's scope there for divergence. On the follow-on damages actions side, obviously a sort of a big and growing industry of follow-on and standalone competition claims in the UK courts. Hitherto, it's been possible to use the European Commission infringement decision as a finding of liability in order to support an action for damages. That ability will be removed, so Commission infringement decisions will no longer be a basis for bringing follow-on claims in the UK. However, I don't think that means that the sort of follow-on industry kind of comes to a halt. I think that there are ways in which those findings of the Commission can be prayed in aid in UK domestic litigation, as infringement of tort of infringement of foreign laws and that sort of thing. And kind of one would expect, I suppose, the UK courts to be quite keen to sort of retain the sort of burgeoning jurisdiction over competition damages claims and kind of find a way to deal with the fact that you can't necessarily rely on the Commission decision as the basis for liability. And then the last kind of main point really, obviously the one-stop shop for mergers which qualify under the EU merger regulation will no longer apply. So mergers that meet the UK test for notification or review by the CMA and also meet the EUMR thresholds potentially need to be notified in both the European Commission and to the CMA. So, John, I'll hand back to you at that point.
Thanks. And we think it's interesting. So one of the things we do here is kind of aggregate data to try and identify trends. And so Nick mentioned the Dawn raids point. So we looked at, I think we looked back about 5 years at the most likely date for an EU Dawn raid. And we found it was a Tuesday. So something like 88% of EU Dawn raids are carried out on a Tuesday. And the reason that happens is, we think, because the Commission spends its time getting its case ready. People don't want to spend the weekend away from home, so the officials carrying out the raid travel to the place where they're carrying out the raid on a Monday, and then I sort of go live, if you like, on Tuesday morning. Just notes, if you like. It'll be interesting to see whether and how the CMA diverge from that Tuesday highlight as things move forward, because obviously the UK is a smaller jurisdiction, so they may be able to travel somewhere on a Monday. So we'll need to watch that. So what does all this mean for me? There are two main areas we think worth looking at. One is the antitrust investigations, and one is the merger control aspects. And really the interest here is in what if there is an ongoing investigation come 31st of December this year, 11 p.m. on the 31st of December, what will happen to those investigations? And it's a little bit unclear. The CMA has put out guidance, but in essence, if an investigation has completed and the European Commission has taken a decision, then the case is closed, unless the infringement decision is appealed and then subsequently annulled, in which case one could foresee a possibility that the CMA will then initiate its own investigation. which could raise some interesting issues, particularly around vertical agreements where there's been an infringement decision taken by the Commission, if that's subsequently annulled, and the possibility that the CMA might take a different approach on those, which could mean that if you have been the victim of an infringement decision in relation to a vertical agreement, it might be worth appealing that strategically as we get past the end of December. Those investigations where the Commission has not yet reached a decision, what the CMA guidance says is that they may be subject to parallel investigation by the CMA. Actually, as a practical matter, probably what will happen is the European Commission will finish its investigation, will keep the CMA involved, but will actually take its own decision, and that decision will be binding in the usual way. So those are investigations that are ongoing or have been completed prior to the 31st of December. After the 31st of December, so post actual Brexit, if you like, then of course there could be investigations by the EU, which do not have mirror investigations in the UK. There could be investigations in the UK which do not have mirror investigations in the EU. And as Nick has already touched upon, there could be EU investigations which actually do involve the UK because, of course, the jurisdictional nexus for competition law is having an effect on the market, and there might be activities undertaken by businesses in the UK which have an effect on the EU market without the UK being part of it, and the European Commission would expect to have jurisdiction over those and be able to investigate those. As at the moment, we mentioned criminal investigations there. Of course, at the European level, so at EU level, there are no criminal penalties, certainly at the moment, so they only exist on a national basis. And one could foresee possibly UK criminal investigations, EU civil or administrative investigations, but then also other EU member state criminal investigations, all going along in parallel. And of course, it'll be interesting to watch the priorities of the CMA as opposed to the priorities of the European Commission. So what we've already seen this year, for example, is the CMA going for more consumer law investigations. So all the stuff around auto renewal, for example, of consumer contracts, funerals, so things that the CMA perceives to be very consumer relevant and on which it can get headlines. That's been a real focus for the CMA, whereas historically, of course, the European Commission has tended to undertake investigations that are more sort of intermediate markets, ball bearings or whatever it is. So it'll be interesting to see how that plays out and whether actually the CMA gets sucked upwards into more of those intermediate cartel investigations. On the merger control front, so of course the UK operates a voluntary system, which many people think is, some clients you talk to think that is great when they first hear about it. Actually, what it does do is create more uncertainty and require much more strategic consideration about whether or not to notify, regardless of the fact that you're not required to notify. So interesting aspect of this, so the EU thresholds have not changed, but of course the UK, which is a big economy, if you like, is now going to be outside the EU, and so it may be that there are fewer cases that meet the EU MR thresholds because the UK is no longer part of the EU. So if you like, the EU will lose out, certainly the European Commission will lose out on some transactions that it might otherwise have had jurisdiction to investigate. Conversely, because the UK revenues of those transactions will now sit in the UK, it's likely that the CMA will have jurisdiction to review much bigger transactions than has been the case hitherto. So transactions with substantial revenues in the UK, which were previously investigated by the Commission under the EU MR, will now fall to the CMA to investigate. And of course, a voluntary system doesn't mean a benign system in the UK. So the the CMA has actually been really quite aggressive and activist over the last year on a number of mergers, including using its hold separate powers really quite aggressively, particularly for non-notified transactions. And those hold separate orders, one could query the jurisdiction, but actually it's applied them on a global basis in at least one transaction. So, i.e., requiring parties that were going to come together to hold their businesses separate pending the CMA investigation. So, although it is a voluntary system in the UK, actually the CMA has been quite aggressive. Nick, what should we be doing? Actually, it's me. What should we be doing? I'm going to cover the first couple of points here, and then I'll hand over to you, Nick. So there are some general things that are good practice, obviously, in relation to Brexit. So the first one is horizon scanning. I mean, it's an ever-changing horizon, but actually, if you find a source of information that is reliable and helpful and speaks to the issues that are of concern and interest to your business, then we would recommend that you continue focusing on that. Obviously, what we always recommend to clients is know what the red in competition law and general regulatory terms, what are the red flags that are relevant for your business, and who are those red flags identified for within your business, and are they the right people? So to give you an example, if there's an investigation launched within your sector, although you're not currently involved, that would be the kind of red flag that you want to know about. And all of that stuff is, of course, stuff you probably currently do, but then there's a big Brexit lay over to it. So horizon scanning. Supply chain reviews, so understanding new tariff arrangements, where your inputs flow from, and how those might be impacted by Brexit. And then Nick, hand over to you for those last points on that slide.
Yeah, thanks, John. I think in the other sort of related point to supply chain reviews is looking at sort of distribution and route to market. I think this is one area where actually there could be potentially quite a sort of immediate impact on the competition law front. You know, those of you who have distribution arrangements which involve sort of territorial allocation in the EU will be aware that, you know, restrictions on sales between customers and territories within the EU are very hard to impose, and they tend to be, you know, tend to easily fall foul of the competition rules, and indeed have been subject a number of markets recently of kind of infringement decisions by the Commission, where companies are restricted cross-border trade between EU member states. Now, when the UK is no longer a member of the EU, as one can infer as a matter of EU law that restricting trade between the EU 27 and the UK will not be something that is subject to those kind of EU rules. I mean, there's a sort of general principle in EU law that restrictions on distribution arrangements between EU member states and non-member states can, in some circumstances, lead to restriction on competition, but it is necessary. It will be necessary for the enforcer in that context to show that there is an actual impact on trade between member states. So I think from the point of view of distribution arrangements, you know, it ought to be possible as a matter of EU law from the 1st of January to restrict sales into the UK from the EU in a much more kind of specific way than has been possible to date. As far as the other way is concerned, sales from the UK into the EU, I suppose technically UK competition law will have sort of imported the kind of EU rules by sort of virtue of the UK Brexit legislation. But that's a pretty obvious area, I think, for development of UK competition law. You know, in the absence of a single market imperative as between the UK and the EU, it must be the case that companies will feel much more confident in saying, well, it's justified to restrict sales from the UK into the EU in their distribution arrangement. So that's an area I think where it's important actually to have a review of what you've got in your documents. I mean, our advice is very commonly to clients, it's important to distinguish in your distribution arrangements between intra-EU sales, where the rules on territoriality and customer restrictions are much tougher. Distinguish between intra-EU from either sales outside the EU entirely or sort of inbound, outbound between the EU and non-member states. And obviously the UK as a territory will have been in agreements as an EU member state. So I think that's an area to have a look at in distribution arrangements to see whether there is any scope legally or any desire commercially to sort of create a more sort of restrictive arrangement around the UK. Last 2 points, regulatory and risk assessments. I mean, this is one of the sort of stating the obvious, but this is kind of one of the kind of biggest changes in regulation in the UK that anyone's ever seen or like to see in their lifetime. It's obviously really important to kind of keep the regulatory impact of Brexit under review, look at what steps you can take to mitigate the risks. Some of them maybe, as we've just mentioned, looking at distribution arrangements, looking at supply chain arrangements and so on. Keeping an eye on what the CMA is up to, I think, is kind of important in this context. It's been a kind of interesting time for the CMA. I think they've, on one view, obviously they're gearing up to take on a much bigger role in mergers, taking on potentially much bigger investigations. And yet recently, Andrew Tyree, the chairman of the CMA, announced he was going to step down, and the sort of the subtext of that, I think, was that he felt unsupported by the government in terms of new powers that he was looking for to take action against kind of consumer and the consumer area. So it sort of remains to be seen how the CMA will sort of bed down in its new role, both as a sort of solo regulator, as it were, but also taking on bigger cases. I think it's quite an important area to keep an eye on. And then finally, competition compliance programs. Will anything change in competition compliance programs? It is worth having a look to see if they need to be updated. If you've got competition compliance programs, just as sort of a very technical matter that says, in the UK, the European Commission could walk in the door, well, in a dawn raid, that's not going to happen. So there are things sort of, if you like, sort of consequential matters that need to be updated. But as and when the UK starts perhaps to diverge from EU law, again, having reviewing competition compliance programs to see whether or not you, as it were, adopt whatever the UK approach is, or whether sort of taking a kind of a global approach and applying the EU rules is perhaps a sensible way forward. But those are things I think that going to need to be kind of looked at as we move into the sort of full Brexit post the 1st of January 2021. John.
Thank you. So last couple of slides. I think you'll see these on a number of the presentations. These are publicly available resources for those that are interested and have a free Sunday to spend looking at the EU exit regulations. We at Field Fisher have plenty of resources. As we sort of kicked off by saying, what we try to do is focus on the practical stuff. We are very conscious that there is a huge amount of Brexit information out there. So I think for each of us, it's about trying to cut through all of the theoretical stuff and trying to focus on what's important for us personally, and obviously for us within our businesses. But if you dig around on our website or email me, Nick, or indeed Andy Hood, who is on that slide. So Andy heads up the firm's Brexit task force. He will be able to find a home for your question. Do we have any questions from the audience? nothing specific. So Nick, maybe we can chat about a couple of things just to finish off. So we talked a little bit in the merger control section about the fact that the UK system is voluntary. And so some people might think if they're considering a major transaction, and obviously merger control rules don't drive transactions, but what they can do is have a big impact on the doability of a transaction, but also on the timetable of a transaction. So some people might be thinking, okay, great, my transaction is particularly going to impact the UK, so we're going to be outside the EU-MR and solely within the UK, which is a voluntary system, so it's going to be much easier. Is that something we can rely on? I think not. I hope you think the same.
I think the same. No, the voluntariness of the UK system is something of a. It's helpful in as much as if you have a transaction that clearly raises no issues, but otherwise it's the threshold. You don't have to go through the sort of the bureaucratic process of notifying. But the reality is that as soon as you have a transaction which might have competition issues, the advice is always very much that should be pre-notified to the CMA in advance of completion, because the the risks of the CMA coming after you after the event, once the deal's been completed, are pretty high.
Yeah, I agree with that. And of course, they've got the Merger Intelligence Committee that monitors market activity. Excuse me, it's actually an area where the CMA can be quite unpredictable. So we've had transactions where parties have decided not to notify. There are two in particular I can think of. So one in which we thought there were potentially issues looking at the data. We got the initial questionnaire in from the Mergers Intelligence Committee of the CMA, filled that in, sent it back to them, didn't hear anything further. They closed the file. Conversely, there was another one where we were confident there were absolutely no issues, and the absence of issues was quite clear, we thought, on the face of the data. CMA sent the initial merger questionnaire and actually got the bit between its teeth and was very, very aggressive in applying initial enforcement orders, hold separate orders, big investigation, only at the end of phase one to go, oh yeah, no, actually there are no issues here. So it can be quite unpredictable, the CMA process, and really depends upon the team you get. If no one else has any questions, it's now 10:35. That's 35 minutes, hopefully, of interesting competition law consideration in the context of Brexit. You'll see highlighted there, 1st of October next week, 10 to 10:45. Nick and I will be talking about state aid and public procurement. Some really interesting issues in both of those areas. So thinking about the CMA as an enforcer of whatever state aid rules we end up with in the UK, and we all know state aid is one of those issues that's actually causing some difficulty between the UK and the EU in seeking to reach a deal. And public procurement, always of interest both to public authorities and bidders as to what the rules will look like post-Brexit. Again, quite political, so public procurement was one of those areas that Michael Gove, I think, said he saw the potential for hundreds of millions, if not billions, in savings if we were able to exit the EU and abandon the vagaries of the EU procurement rules. So we look forward to that, and we hope to see some or all of you at the same time next week. Thanks very much.
Thank you.